Okay, any questions? Barclay and... Barclay goes here? Yeah.
A question for each of the speakers. For Jean-Philippe, you seem to emphasize the sharp contrast between someone in a traditional religion subject to witchcraft, kinship obligations, and so on, converting to one of the major monotheistic religions. I think I know what your answer is, but you didn't address it. I'm curious if you see any significant difference between Christians versus Muslims in Africa. For Professor Leiden, it seems, I guess I'm not entirely convinced with your argument, and I think there's another thing that's going on here. You note the use of the Maliki Code in Africa and how this, in fact, allowed for written contracts to some degree. You noted some cases, such as this case in Fez, that undermined it, but that was a case where you had a witness and a contract versus another witness and a contract. So it's not clear to me that that's undermining written contracts. I mean, it's lying witnesses and lying contracts, and it's not clear what's going on. I think where you really are have something going on, and there needs to be more explanation, is why didn't they get these notaries? And somehow this seems to be having to do with states, that somehow the states somehow didn't see this interest in legalizing these notaries. And it's not clear to me that that has to do with Islam or the Hanafi or Maliki Code or whatever. By the way, I also would be a little bit cautious about focusing too much on this issue about money undermining people. It's true. I mean, it's in the Quran that gold and silver are money, and in Saudi Arabia, the paper money actually has silver in it. But I'm wondering about if if really it has something to do with state power with regard to the notaries.
Okay.
Yeah, my questions are addressed to Professor Leiden. First, I want to give you credit for this paper because the absence of documents in the court records have been always taken as a proof that merchants didn't keep records. But you show by proof that merchants did keep records, however, they weren't taken in the court. However, when you pinpoint this puzzle, the answer is yet not given clear. You point that there was a fear of forgery of the documents. However, other documents like the ijaza, the degree of the educated was taken into consideration and believed, and also legal learning were documented down and passed through generations. Another point is that you give the increased number of muftis throughout the centuries as a proof for increased consumption in paper. However, this might be a reflection of the survival of the documents itself that muftis left. Also, of the increase in population. The more people are there, the more problems, and therefore the more iftas are needed. A third point is that if really there was a difference between Hanafi and Maliki schools in taking the written documents into consideration, then the question will be, is there a difference in their business performance?
Hi, thanks. This is a question for Ghislaine. The evidentiary rules make a big difference in our legal system, but that's because we have juries. And so that there's one person who's deciding whether the evidence gets in or not, and then a separate group of people who decide facts on the basis of what gets admitted. And in a bench trial system where you have the judge deciding both of those questions, it's basically a mind game, because the judge knows that the evidence is there and then doesn't admit it, but big deal, right? And as I understand Islamic courts, it's basically a bench trial system, in which case, I would be surprised in cases where there is a contract that the judge doesn't know that the contract exists and doesn't know what it says. And if that's the case, then for the vast majority of disputes, you're going to get the same result, whether you have the contract being admitted or whether you have the witnesses coming in testifying to what the contract says. So I'm trying to think, where would it make a difference? And I get, intuitively you might think, well, maybe if it's a forgery, it would make a difference, except that's wrong. If the defendant can show in the American legal system that the contract is a forgery, then the plaintiff can't collect on it. So whether it's Islamic or a Western legal system, forgeries aren't, forged contracts can't be sued on. So then the only other thing that I could think of that would be a difference would be in long-distance trade. Let's say you make a contract in city A, and then the defendant has disappeared to city B, and all the witnesses are going to be in city A, and then to try to collect from B, you got to go to city B to collect, and then you don't have the witnesses. So maybe that would make a difference. Now, if that's the story, if that's basically the only place where this rule has any bite, then I think what you need to do is you need to expand the jurisdictional rule aspect of this, because it strikes me as plausible, and I have no idea whether it's true or not, but it's plausible that if that's a real problem, then the courts may have had different jurisdictional rules such that if all the witnesses are in city A, then even if the defendant's in city B, you could basically sue in city A, in which case then, again, even that situation would potentially not result in that different an outcome.
Okay. Why don't we have some answers, and then we'll have a few more questions.
Okay, do I start? So I have essentially one question to answer, which is the one by Barclay. Yes, of course, there are both similarities and difference between Christianity and Islam. Let's first start with the similarities. I think the first profound similarities, and which matters so much with respect to the main argument made in the paper, is that both Christianity and Islam preach a kind of equality and brotherhood. And this equality and brotherhood is supposed to be defended with reference to a universal community or brotherhood, and which means that people should have the same chance irrespective of their identity or their traditional identity, like ethnic identity, their position in the social structure, etc. And in that sense, both religions open the way for individual emancipation from the traditional fixed position in the erstwhile social structure. Now, coming to another basic similarity is that they both prohibit lavish expenditures and ancestors' cults. At least, and I had field survey very recently on that in Mali, in traditional areas in Mali, at least they all say, whether it is Muslims or Christians, that they have to stop the ancestors' cults, and which means essentially participating in festivals where there are lavish expenditure and a lot of alcohol drinking. In some other respect, they still maintain the ancestor cult. But in the most visible manifestation, which involve a lot of consumption and lavish consumption, this is prohibited. And in a sense, many people who are keen and bent on capital accumulation find this very convenient because they have an easy excuse to say, no, I don't attend because I am a Muslim, you see, or because I'm a Christian. And that is accepted by local people because they are referring to another spirit than the traditional ancestor spirits. Now, as far as differences are concerned, the main difference is that Christianity prohibits dowry, Islamic inheritance, and polygamy, whereas, of course, Islam does not. And that, I must say, is taken rather seriously. For instance, if you really convert into a Christian religion or sect, I mean, you have to drop polygamy, yeah. That's the main difference that I see, whereas those who want to remain polygamous, then they won't convert into Christianity, would prefer to convert into Islam. Yeah, I think that's the main difference. No, I want to add that there is a difference within Christianity between traditional understanding of what is Protestantism or Catholicism and between the sects which are now gaining so much importance, not only in Africa but also in Central America, like, for instance, the Pentecostal Church. That I think that is really different. Why? Because the Pentecostal Church, in a sense, is perceived as much closer to traditional magical practices than the Christian religion, the modern official religion. And so the importance, for instance, of the ritual of the descent of the Holy Spirit on the people in the Pentecostal ritual is something which appeals a lot to the people, because they can see very many similarities between that kind of magic, between quotes, and the kind of magic they are used to. Of course, you could say that the Holy Communion in the Christian church is also a magic operation, so people can easily get to that because it's magic in both sides. But the Pentecostal kind of church are very appealing because there is, for them, the syncretism with their traditional magical practice is much more straightforward than with Islam and the official Christian religions.
There's an interesting case about a woman who purchased a house in one of these oasis towns and then asked on the basis of Islamic law on revocation, the iqala, that she wanted to return the good because it was defective, otherwise known as the house, and it was stated was infested with ghosts. And so, of course, she was granted a wish because the ghosts were not declared, which is sort of the point about Islamic legal practice and legal hybridity. Thanks for the very stimulating questions, and some of them I can answer and some of them I can't. Certainly the history of notaries in Western Europe and elsewhere is something that I'm just starting to understand much better. And Richard put a nail on it in terms of identifying the stamps. I have a little paragraph about stamps and signatures in the last version of the paper where I sort of indicate that looking at these official seals that are state-sponsored are important, but I also note that having visited the archives in Tripoli lately, that seals were actually used in the Ottoman Empire, it seems, or at least in the Libyan example, as signatures, official signatures that actually could, I actually bought a little seal in the Medina with my name on it that you could buy for a couple of bucks, which were used actually in the court of law, in the sigilat, for people to actually stamp underneath to put their names on, because obviously they're a lot harder to forger. But so the relationship between notaries and state power is certainly somewhere to look for. The case, I think the Fez case, which is really interesting in and of itself, because it really unveiled for the mufti who's writing the fatwa the quintessential problem of revealing in a court of law that somebody had lied. Because basically it undermines the entire system based on the shahada, or the swearing, and swearing meaning on the Quran, and swearing all divine, linked to the initial confession of the religion, the swearing that there is no God but God. When the case was not just one witness. It's a case of an agent and a contract. They each have a copy of the contract, but then somebody forges the contract, finds an additional witness, and so the Qadi was wondering how he should introduce these documents so as to determine which is the real contract by bringing in the witnesses, and should he ask the witnesses to reveal what's in the document, or should he show the document to the witnesses to have them authenticate it. So it's really poses a core problem, and I think because of the lateness of that particular contract, because that particular case, which is 17th, 18th century, it might sort of be indicative of the types of problems that were being posed in an increasingly literate society with more multiplication of contracts. And in a Maliki situation where there is this flexibility, according to Ibn Farhun, who's this 11th century Maliki scholar who posed that question quite clearly, that anything that reveals the truth can be and should be used. So there's that flexibility. Now, in terms of paper money, a number of fatwas in Mauritania discuss the imposition of the colonial French franc in the form of a billet de banque, otherwise known as a banknote, for all kinds of different reasons. How can we trust this piece of document by the colonial overseer and overruler? They were asking questions about trust, being, is this a good, bill that will ensure that I can get my money's worth, so to speak, but also sort of fundamental questions about the paper itself, that it can be eaten by termites, that it can be blown away in the wind. And so there's these debates that I think are extremely indicative of other things than the actual faith in the sovereign issuing the currency. The questions are about the documents. In fact, I was talking to Ron Harris yesterday about the idea that hopefully maybe one day in our living there might be somebody who discovers another Geniza records ensconced in some mosque or in some synagogue that will reveal more private information for the Middle East. In this particular context, the preservation is I think also indicative of a value placed on the written word, and a value placed on documentation in this area, which can be linked to some extent to sort of religious practices, talismans in sort of illiterate Muslim societies in Africa who really venerate any written documentation with the word of God imprinted on it. But that's a different discussion altogether. Does the increased consumption of paper lead to efficiencies in trade? And it's something that I actually argue in my larger project to some extent. The 19th century really does witness this huge volume of trans-Saharan trade in all directions, and I think that the efficiencies in that increased volume can be the use of documentation can indicate those efficiencies. But on the other hand, one has to understand that before there were Muslims in Africa, there were Jews in Africa, and Jewish communities actually had the reins of organizing trans-Saharan trade at a time of a Roman North Africa, and subsequently until the rise of Islam. Jewish and Muslim merchants would collude in trade subsequently, which is where the interfaith contract, another topic, is interesting to see. So in that sense, literacy led to efficient trans-Saharan trade networks that have long-standing history. But because of the increase of availability of paper and increase of literacy, perhaps it's very difficult to prove, obviously, but I do believe that led to efficiencies indeed. And so the consumption of papers by muftis was also, and I focus on the consumption of paper by muftis, but also they're dealing with social questions that have to do with really immediate problems of exchange, the currencies, and as one particular mufti put it, Al-Mami, he said there's so many more situations now that we're facing, and he's a 19th century mufti, and he's talking about pressures that are completely linked to what's happening on the Atlantic coast in terms of international trade, and the ways that environments are being affected by a lurching about to occupy European